Good evening and welcome.
Thank you, Chairwoman, and thank you for the committee for this important conversation and this long night. I was in the other room, so I just wanted to address a couple things I did hear. Senator Aptakis, the Attorney General, has filed his intention to file legislation increasing long-arm purchasing up to 21. We did a final draft of the bill today. It should be in the hands of Senate staff by the end of the week, so we are filing that legislation. I know you have a long night tonight, so the Attorney General is opposing 2148. We are supporting 2442. We are supporting 2319, the high capacity ban. We are supporting 2493, the assault weapon ban. We have filed lengthy testimony on all of those bills, so I'm just going to talk about the bills that we have significant concern with or that we have sponsored. On Senator Goodwin's bill, Whip Goodwin's bill, the red flag bill, we are in full support of that bill. We are working on amendments that are mainly technical in nature to tighten that bill up, and we are happy to work with Whip Goodwin and this committee to do that. There's a couple of points that I wanted to bring up, though, from our sister state in Connecticut. They started doing risk warrants in 1999. From 1999 to 2013, they issued 762 of those orders. Firearms were found in 99% of those 762 orders. And of that 99%, at least an average of 7 guns were found per individual that the risk warrant was given out for. So it's clear that red flag orders save lives. So we're thankful to Whip Goodwin for putting that bill in. Regarding Senator Sheehan and Senator Sevigny's bump stock bill, when the bump stock incident happened in Las Vegas in the fall, our office was forced to look at our current laws to see if bump stocks were illegal. We made the determination that if someone attempted to make a gun automatic under our law using a bump stock, that would be illegal. We also found if someone was in possession of the tool while in possession of the gun, we could show intent to make it automatic. That would also be illegal. But the mere possession of a bump stock is not currently illegal on Rhode Island law. We think that it needs to be made very clear in the general laws that these tools are illegal to possess and to use, and these bills do that. And I did attach to your testimony a letter about over a majority of the attorneys general nationwide sent to Congress.
Joey, I hate to interrupt you, but I know you were listening to a great majority of the testimony.
Yes.
The only question that came as a result of that bump stock bill had to do with giving some sort of notice or a time frame if that bill were to be enacted for those
Yes.
people who did own one so they didn't automatically become a felon. Is that something that the general could support?
Absolutely. We've been talking about that a lot. When you have normal assault weapons bans like the 18 to 21 ban, that bill will be looking forward to. You could track it through a serial number. Bump stocks don't have serial numbers, so we would absolutely support a grandfather clause. We've spoken about it.
Senator Archambault.
Joey, in the collection of, I know that the red flag bill is not your bill. In the collection of data that you've looked at between Connecticut and other states that have enacted similar legislation, have you looked at the period of time for the restraining order hearing and the due process commensurate therewith? I'm looking at the number 7, and I'm wondering where that number came from. And I'm thinking of last year with the other bill that was passed for the gun violence, and you know there's a problem with the restraining order that's trying to be worked out now with the Supreme Court because mechanically it just doesn't work with fundamental due process. As good as that bill is in many ways, that there's an issue there. So I'm thinking of that when I see the number 7 here. And you're always good with statistics. Can you say anything to that?
We know that other states, I think that Washington has 14 days. California might have 21 days, but it's in that span, that 14 to 21 span. I have all the bills in the Senate Judiciary office for the 5 states that I can certainly break down to you which states do what with numbers for the time for the hearing.
And I'm curious if I could follow up, Madam Chair, and I'm curious as to what may be the lowest number of days that one could have a hearing to protect fundamental due process, because the thinking of some of the prevailing minds who deal with this every day in family court and the district court is that there needs to be a shorter period of time, and then that time would include a full hearing so that these property rights can be dealt with right up front with the allegations so that due process is fully intact. I know you're familiar. with
Yep,
what
I
I'm
will
saying.
get you those numbers.
Thank you.
Moving on to Senate 2134, which is Senator Archambault's bill. We did put written testimony in. The Providence County Gun Court, where a vast majority of our gun crimes and gun prosecutions take place, they issue a report monthly. So that is the report that provides all those numbers. We think that creating a report of this nature would be duplicative in nature, and people always actually have the ability to file an APRA request or look on the court documents online that are all there to see our dispositions. But I did want to comment to something Mr. Sakosha said about 90% being cleaned down, and I haven't been able to find that on the Providence Journal, but I certainly will. I mean, holding the Attorney General accountable, which I hope that all voters in the state would. But I think that people need to understand that when a gun case is charged, there's probably about 7 different counts that are charged. And any normal plea deal, counts of that will be dismissed. So just because there are counts of the indictment or information dismissed doesn't mean the case is dismissed. And regarding the gang member in Johnston in February, when our office does an investigation regarding a criminal complaint filed by local law enforcement, having that go through our screening process does take a while. And it's unfortunate that the person was let out on bail, especially if he was a fugitive from justice, but there are only several crimes in our state that are held without bail, and those are set by the Rhode Island Constitution. Gun crimes aren't part of them. Bail is presumed in gun cases, so following the bail guidelines, the person probably appropriately did get bail. If he was a fugitive of justice, that needs to be really looked at. But I did want to point out that gun cases are not held without bail cases. If they are, the Constitution needs to be amended.
Senator Archambault.
Thank you, Joey, and I appreciate that you have mentioned that there may be some duplicity with the bill, but you know that as the top law enforcement officer in the state of Rhode Island, the Attorney General is the one we turn to for a feeling of soundness, that the statistics coming out of that office are accurate and the data is something we can rely on. And right now, we don't have a reporting mechanism for the General Assembly, so I'm not so sure that the burden on the agency would be so great that we couldn't have the Attorney General's office take what's presently out there, streamline it with this bill, and then annually have someone as articulate as you and as well-informed as you come before the General Assembly on behalf of the Attorney General and enlighten us as to what those statistics are so that we can adapt in real time, because the incidence of crime is something that concerns everybody in the room, and we want to make sure we're doing the right thing with any adjustments to things. So and it's your office that's looked upon for the veracity and soundness of those.
And we do issue an annual report every year to the General Assembly about what our office does as a whole, including our crime statistics. So I'll bring a copy of that. We just think it would be duplicitous to do it more. In regards to Senate Bill 2274, that is a bill sponsored on behalf of the Attorney General, and that's the carrying a long gun down the road. Right now, an 18-year-old could go into a gun store, buy an AK-47, and walk down Smith Street to no avail. That's completely illegal in this state. We find that troubling. We call it the Omer exception in the wire, where someone can just walk down the streets of Pawtucket, the streets of Warwick with a loaded long gun, rifle, or shotgun. This bill attempts to codify what we do for concealed carry permits, but do it for long guns too, but not get the permit. And I wanted to point out something Frank said, that he was concerned about this bill because it would create a new defense for people, that they would have to hire a lawyer to defend themselves in this case. The same exemptions for long guns are the same exemptions that have been in the law for short guns for the last decades. So this doesn't create a new standard. Everyone that carries a firearm understands the provisions of having it in their home, their vehicle, or in their place of business. So the same exemption would apply to the long guns. We think it is very dangerous that people can be walking around our state with a loaded shotgun. And that's currently the state of the law. It occurred in Central Falls a month ago, and Colonel Mendonça can talk to you about that in a little bit. On 2276 right now, for a minor to be convicted of possession of a firearm, they must also use it. We know that in our urban core, gang members are using the youth to hold on to their weapons because the penalties are less, if at any. So we think this is a very dangerous loophole in our law that we're waiting to charge a minor in illegal possession of a firearm just because they didn't discharge it. We think that's a very bad signal to send. In regards to Senator Coyne's bill, Senate 2455, bringing full jurisdiction of concealed carry permits to our office, we are in full support of that bill, and there's 3 things I want to point out regarding that bill. Having 2 concealed carry permit standards is very inconsistent and creates confusion, let alone when you do the 2 different laws and then there's 37 other agencies interpreting those laws. Of 2 distinctions, though, AG concealed carry permit holders are subject to the 7-day waiting period. Municipal concealed carry permit holders are not. One of the biggest things that makes 7-day waiting periods so important is the NICS check. If the federal government runs a NICS check and the conviction is incomplete, they call back to the jurisdiction to get the court records. If there is no waiting period, that gun is being sold without that confirmation being complete. So it's really ridiculous to have the AG permit holders subject to the 7-day waiting period, but not the municipal carry holders. That's inconsistent. The other thing that's the difference is that the AG permits are entered into NCIC, which is the Federal Criminal History Database, meaning if someone gets pulled over in Rhode Island and has a concealed carry permit, law enforcement can see if the person has a concealed carry permit, which is a public safety standard for both law enforcement and the concealed carry permit holder, so everyone knows there's a gun involved. For the municipals, they're not entered in. So there's no knowledge by law enforcement if you have a concealed carry permit and they are pulled over that the person has a gun on them. And we think that's a safety issue. And then finally, we do the vast majority of permits in the state. The last time we counted, it was above 80%, but those numbers might be different. That was several years ago. But we are doing a vast majority of the concealed carry permits. And this year, 2017, we had 2,335 active permits from the AG's office. We had 645 new applications. 83 of those were new applications, and 565 were renewals. The next bill is Senate Bill 2456, and this isn't really a gun bill, but it has to do with concealed carry permits. Right now, our office and law enforcement have no way to do a fingerprint check to the FBI for a national background check. We don't have the statutory authority. For the FBI to accept our prints, we have to have a statute that says they can. So that leaves us looking through III on every single state's record to complete a national background check, which is entirely burdensome when all that would have to be done in a normal cycle is just send a print and have it come back. That's what we do with every national background check in the state, but we can't do it with this concealed carry permit application. It's really a no issue other than the price of the background check, which is $35 for 4 years. But it's really an administrative burden for our office and law enforcement. For Senate Bill 2606, that is a bill sponsored by us, by Majority Whip Goodwin. That's about the orange tips in the laws. We've seen incidents over the last 5 to 6 years where people are removing the orange chips that are federally required on toy firearms or imitation firearms and removing them to make it show it's real in a robbery or a B&E. Or people are inserting the orange chips into a real gun to make it appear fake. We have alteration of firearms in our general laws that that criminalizes people that alter firearms. This would include orange chips into that alteration. If you put an orange chip into a real firearm, that would be a felony under this bill. And if you remove the orange chip from a toy gun to be used in that crime, it would be a misdemeanor. And we have seen cases of that in Rhode Island. And then finally, 2615, which is Chairman Miller's bill about straw purchases. A straw purchase is when I go buy a gun for Colonel Mendonça, who's not lawfully allowed to have a gun, and I buy it and give to him. That's a straw purchase. States across the country have that bill, have that law. It's been held up by the United States Supreme Court in 2014. Rhode Island doesn't have that law. So if anyone is making straw purchases in Rhode Island to evade federal and state statutes on who can carry and purchase firearms, there would be no way to charge them criminally under state law. That is a very big concern that should be addressed by this body. I will rely on my written testimony. I'm open for any questions.